All right, good morning. No Zoom today, so you guys had to get out of bed and show up in person. That's good. That's healthy. Very, very, very good. Welcome to my annual visit, my 40th anniversary tour of California. Wow. Amazing. I've been coming here 40 years. I will say this every year. You know, you guys have like the nicest facility of any place I go to, so good for you. It's always a good time. This is a good time for me to come because, as you probably know, this is the time of year when all the new laws get passed. It's also a time of year when forms change, so that's what you want to hear. You want to hear about new laws and new forms. You probably would hope there's few new laws and forms as possible, right? The shorter my speech is, the better for you, right? Because you got to learn all this stuff, and then they keep changing it, which is a real pain, isn't it? So I would say this year, compared to other years, it's not as bad as some years. So no, that's good. But here's a slight problem. Usually I come here after the deadline for all the new laws to be signed. But this year it got extended. So the deadline for the governor to sign new laws is Sunday. So there are some laws sitting on his desk right now that are actually relevant to you. I'm going to mention those. We think he's going to sign pretty much all of them, but not guaranteeing anything on these ones. I mean, he has signed some, of course. I'll talk about those. But there are just a couple really important ones that he hasn't signed, but he probably will. But I'm going to talk about those, but just keep the distinction in mind. Now, on Monday morning, so his deadline is Sunday, like midnight. Monday morning, we will send to every realtor, we always do this every year, an email. Attached to the email is our written summary of all the new laws. So you don't really have to take notes on what I'm saying today because it's all going to be there. So be ready for that. Of course, I'm also going to talk about some form things. I'm also going to talk about some other stuff that isn't specifically new laws. I'm talking about new regulations. You remember last year I only talked about one thing? Buyer broker. Can you believe it's been almost 14 months since D-Day? We're always going to remember 2 days, December 7th, 1941, and August 17th, 2024. And you young people are saying, what's December 7th, 1941? I'm not even going to tell you. But the point is, that was a big day, a huge day, and there have been some developments since. I'll talk about that. But first, let me just talk about some new laws. A couple of the governor just signed a couple days ago, so it's interesting to talk about those. One of them, there's a new disclosure coming up. You're not going to believe this one. You've all heard of secondhand smoke, right? Have you ever heard of third-hand smoke? Seriously, there's a new law. But if you ever think about this law, it's a little kind of crazy. There's going to be a new disclosure obligation for sellers when you're selling a house to disclose if there was any third-hand smoke. What does that mean? Does the seller have any actual knowledge that there's any residue from smoking tobacco or nicotine products in the house, like in the carpet, the walls, or whatever? I think it's really just asking the seller, did people smoke here, right? Because who knows how much smoke has to happen before there is residue that's, toxic in the carpet or whatever. So there's basically going to be a new question on the seller property questionnaire. By the way, there already is a question on the SPQ regarding smoking. So it's simply going to be enhanced a little bit. And I think the advice you're going to give a seller is, when in doubt, say yes. At least one time somebody smoked here. You know what I mean? You can't go wrong in saying, unless you're 100% sure no one has ever, there's some houses where, the people say, no, you can't smoke here, no one ever smokes here, and you're pretty sure no one ever smoked there. But what about the people who owned it before you? I guess if you've owned the house for 50 years and you're 100% sure that no one ever smoked, then you can safely say to that question, no one has ever smoked here, there's no possibility of any residue, blah, blah, blah. So it only applies to TDS transactions, 1 to 4. Doesn't apply to probate, REO, bankruptcy, trust sales. Doesn't apply to anything other than residential 1 to 4. There'll be a new question on the SPQ. And also there's going to be a new chapter, believe it or not, in the environmental hazards booklet talking about this. So only in California, I think. I don't know any other states have anything like this. But that's the latest thing. The governor just signed it a couple days ago. It's a disclosure. Your sellers will see a new question on the SPQ. It's a good thing. It's very specifically, the law even says it's not a realtor disclosure. So in other words, you don't have to ask your seller or be aware of the smoking history in the houses you're selling. The law spells that out. So it's a seller question. It's a seller, and remember, when the seller fills out the SPQ, you're really not supposed to help them. I mean, it's because it's supposed to, because if you help them, then they'll come back and say, I didn't mean to say that, but my realtor helped me fill that out. You can do it, but that's what's a possibility. We always say, give them the forms, tell them to figure it out the best of their ability. Of course, in reality, they're going to come to you and say, how do I answer this one? And one response you could have is, I'm not telling you, or it's not my area. But of course, that makes you look bad. So you do what you got to do, right? You know. Speaking of that, there's another new question on the SPQ that's also similar to a one that's already been there, which is going to ask the seller, more or less, are there any restrictions where you're selling, in the area where your house is located, are there any restrictions on replacing gas appliances? There are places in this state, not here. I'm 100%, 99% sure. You tell me if I'm wrong. There's no Bakersfield or Kern County rule that does this yet. But there are large parts of the Bay Area and south of here where local governments have passed laws saying something like, if you have this type of water heater and you want to replace it, you can only replace it with this type of water heater. Or some places you can only replace it with electric. So there's a question on the SPQ then where the seller has to disclose that. But once again, that's always are you aware? So the seller's going to say, I don't know. I don't keep track of this stuff. So they might come to you and say, how do I answer this question? Are there any local rules here regarding replacing gas appliances of any kind? Once again, your answer could be, not my job to know that. Once again, to make yourself look good, you want to go beyond that. And the answer is, I'm pretty sure you guys would probably know better than me if it was not true, that there aren't any around here. So you can probably safely tell your sellers, that question you can answer no. There aren't any laws along those lines here yet. Okay, so that's sort of the way to look at it. Okay, so that's the latest on disclosure. Let's talk about some other things. A big issue that is becoming a bigger and bigger issue is wood balcony stuff. Okay, remember the basics. The basics are every residential building in California that has 3 or more units that has a balcony, deck, or outdoor staircase made of wood has to be inspected. I mean, those that are 6 feet off the ground. 6 feet off the ground, made of wood, it has to be inspected no matter what. And it can only be inspected by certain people. It can only be inspected by architects, engineers, and certain types of general contractors and building inspectors. The confusing thing is there are 2 different laws. There's the law about apartment buildings and there's a law about condominiums. So this does not apply to single-family homes. It doesn't apply to duplexes. But if any of you have or are managing or are selling a triplex, fourplex, or bigger, you have to look at the building and say, are there any things sticking out from this building 6 feet off the ground that people stand on? And are they made of wood? And if they are, someone has to inspect them by the end of the year. And if the inspector finds a problem, they have to be fixed within 4 months. And actually the inspector, there are 3 possibilities the inspector is going to say. One, he's going to say, everything looks good. Continue to stand on your balcony. It's not going to collapse and kill you. You're good. The second possibility is there's dry rot here, there's problems. In my personal opinion, this is moving in the direction of not being safe to stand on. You need to repair this within 4 months. I'll be back then to see it. And by the way, the same person who makes that recommendation can do the repair work. That's okay. The third possibility is the inspector says, this is dangerous now. No one should be standing on this balcony. Block it off. Deny access to this balcony immediately. And we'll be back in 4 months to see if it's done, okay? So those are the three possibilities. Now you notice the deadline to do this is end of this year. The deadline has not happened yet. So that's point number one. But then this law also applies to a certain type of common interest development, namely condos. Remember, there are different types of common interest developments. There's PUDs, there's community apartment projects, own your own, PUD. It doesn't apply to those. But this law applies to condominiums if the condominium is in a building with at least 2 other condominiums and any of the units in that building have balconies or decks made of wood 6 feet off the ground. So the HOA is responsible for inspecting those. But you know when the deadline to do that was? End of last year. How many of the HOAs in this state do you think inspected their balconies by the end of last year? Like 10%. Nobody did it, but they're catching up now. I mean, this applies to me personally. I have a rental property in Culver City. It's a condo, so it's a single-family home. My condo doesn't even have a balcony. However, my condo is in a building with 25 other condos, about 20 of which have balconies made of wood. So my HOA should have done the inspection by the end of last year. They didn't. They finally did it this March. We still don't have the results yet. Anyway, the point is, number one, there's the responsibility to do it. But number two, relevant to you, there's a disclosure obligation. So if you today are listing either a triplex on up or a condo in a building with 2 other condos with balconies, your seller, and you're going to help them do this, so obviously it has to disclose to the buyer, have they done the inspection yet? If so, what were the results? If the results were they need to be fixed, have they been fixed yet? So we got a form for all this. It's great. WBIA, Wood Balcony Inspection Addendum. It covers all this. It explains what I just said. But remember, think of that. That's a mandatory form if the property you're selling or listing fits into the description I just said. Okay? So you got to do it. I mean, obviously for condos because the deadline's already passed, but even for maybe you're listing a 4-plex that has balconies. The owner of that building has no obligation to inspect it yet. It's not till the end of the year. We're almost there, but they don't have to do it yet. But if you were selling it today, you'd have to disclose to the buyer, yep, this person has not done the inspection yet. Or they have, and this is what the results are. So mandatory disclosure and mandatory do the work. Now, what if you live in a condo and your HOA hasn't done the work? I don't know about you, but we've been running into places, in LA at least, where lenders are not allowing anybody to sell, and they're not loaning on the building. They're saying, we are not loaning until we get certification from the HOA that they've inspected the balconies. So this is messing up sales. Hopefully not for you. But nothing you can do with the HOA won't do it, right? I mean, you need the HOA to do it. By the way, did any of you go to Reimagine a couple weeks ago? I went to a lot of legal meetings. And you know what one of the biggest themes of all the legal meetings were? I hate HOAs. That was the biggest thing, you know? Nobody could stop talking about how much they hate HOAs. And, HOAs should be regulated, blah, blah, blah. Anyway, but they're not, so you got to deal with it. The point is, okay. And then let's say you're selling a condo, right? The standard thing you do, escrow does this for you, you ask the HOA, please provide the disclosures to the buyer. In other words, CC&Rs, budget, reserve study, rules and regulation, bylaws, et cetera. But nothing today even requires the HOA to tell the buyer anything about the status of the inspection of the balconies, which is why you guys, C.A.R. sponsored a law that the legislature passed saying, oh no, this is now part of the mandatory HOA disclosure document package. So when you sell a condo, the HOA is required by law to include in the package, you know, a certification of what happened with the inspection of the balconies. This is one of the laws that's sitting on the governor's desk. It was passed like unanimously. And when a law passes unanimously in the legislature, I don't know if I can ever remember hearing a governor veto such a law. It could be overridden anyway, but he hasn't signed it. His deadline is Sunday midnight. I'll be shocked if he doesn't sign this one, but he hasn't. So well, you'll find out, just like I'll find out by this weekend. So, yeah.
This is probably a strange question.
Yeah.
But does this also apply? I know the Contiki Hotel in Pismo has been closed because it's redoing all of their.
Doesn't apply to hotels.
That's why I wanted to know.
Yeah.
Does it? Because
No.
I haven't.
Yeah. There might be another law for hotels I could look up. Yeah, this law particularly doesn't apply to that. Yeah. So, any of it, and it doesn't apply to commercial properties either. Right. Okay. So, looks like that's going to happen. But that, of course, doesn't solve the problem of the HOA that just hasn't done it yet. And then you just got to deal with that the best you can. And hopefully it's not going to kill too many deals, but it has killed some deals in the LA area. So, anyway, by the way, another good thing about this law that we're pretty sure the governor is going to sign is right now there's no standard form that a person who inspects the balconies has to use. They all just come up with their own. But there is this law that the governor we hope is about to sign, also has a standard sort of cover sheet that everyone, you know, it's going to have to say, you know, yes, you know, this complex has X number of units, X number of those have balconies, we've inspected X number of those, X number of those have problems, and you know what I mean? There's a standard form for condos. There is no standard forms for inspecting apartment buildings, but at least there's going to be a standard form for condos, which leads to an interesting question. So my condo building, for example, has 25 condos, 20 of them have balconies. So my HOA is supposed to inspect the balconies, but do they have to inspect all of them? So there are 20 of them. Can they just inspect one or two and say, these look good, I'm sure the rest are good? Or do they have to inspect all of them? You know what the answer is? They have to inspect a statistically significant number. So we've done some research to figure out what that term means. You know what that term means, roughly? 80 or 90%. So they're going to have to inspect 16 or 7, or they'll probably just inspect all of them. But anyway, so that's the latest on the balcony thing. Yep. Oh, yeah, very good question. For condos, you have to inspect them every 9 years. For the apartment buildings, every 6 years. There's one more twist on this. This only applies in condo buildings if, by the way, the house I live in is also a condo, but it's a freestanding townhouse. It's not attached to any others. And I do have a balcony on that one, but it's decorative only. No one stands on it. But that one doesn't have to be inspected because that building, that is a single-family residence not attached to any others. Why should that matter? If you have a balcony and they should be inspected, shouldn't they be all be? But thankfully, it doesn't apply to single-family homes or duplexes unless the single-family home is a condo attached to at least 2 other condos. But guess what? There's also, the law also makes it clear that this is an HOA responsibility only if the governing documents say it's the HOA's responsibility. For example, some CC&Rs say maintenance of the balcony is the responsibility of the unit owner. If that's the case, no inspection required by the HOA or the owner. Well, guess what? There's a bill sitting on the governor's desk that would say HOAs can't transfer the responsibility. But that one, I'm not sure he's going to sign. Stay tuned. Stay tuned. I know what you're saying. Gov, why don't you come next week? And yeah, so I don't know everything yet, but that's the latest on that. Okay? All right. Questions on that? Okay. Next, yeah.
Just to be clear.
Yeah.
The inspection should be done by an architect, an engineer, or a home inspector?
No, not a home inspector. Certain types, it's all on the form, I haven't even memorized, and certain categories of general contractors. By the way, if it's a condo, it can only be architect or engineer. If it's an apartment building, it can also be certain types of building inspectors, certain types of general contractors, okay? And it's good for a certain period of time. Yeah? Exactly. But there are a lot of condominiums. You're right, it does not apply to PUDs. You are 100% correct. There are a lot of condos, yeah.
So is this opening a can of worms?
Hang on here.
I can just repeat the question, otherwise you're going to be running all over the place.
Is this opening a
Whoa.
can of worms for homeowners of those condos to sue the homeowner association?
You can always sue the homeowner association. Anybody can always sue. The result of that is the HOA is going to increase your dues and assess you to pay for the lawsuit that they have to defend from you. It's like a losing situation. But yeah, you can do that. You certainly can do that. All right, yeah.
You have to say any date that is effective, meaning, thank you, meaning if they're built before 1978 or after 19.
No, nothing like that.
There's no date.
No date thing at all. Yep. It applies universally. All right. Next topic. What's the latest on fire issues? And there's another pending law that we think the governor's going to sign that we'll see. First of all, big picture. Here's a couple things that have happened since the last time you saw me. Number one, CAL FIRE finally finished mapping the entire state. Every residential parcel in California has been determined to be either in a very high fire hazard zone, a high fire hazard zone, a moderate fire hazard zone, or nothing. Everyone's in one of the four. All right. That's point number one. Point number two, you all know there's a consequence if you're in the top two. The consequence is, number one, you are required to maintain defensible space around your property. And number two, when you sell that property, you have to fill out a form. Fire hardening defensible space. Okay. What else has happened recently? Well, one thing that has happened for sure is you've probably noticed on the form itself, if you've looked at it, there used to be 6 questions for the seller to answer. Now there are 18. Let's back up for a second. So every single seller, every single property owner, if you're in the category, you have to have defensible space. And what that means is any day of the week, unannounced, without invitation, CAL FIRE or your local, the Bakersfield Fire Department can show up at your house. Take a look in your backyard and say, within the 30-foot zone there, those 2 trees are too close together, cut one of them down, or something like that. They can do that whenever. So that's one reason you want to maintain defensible space. Another reason to maintain defensible space is for your own safety, right? Okay. But there's also obviously this disclosure obligation. So first question is, I'm selling my house. How do I know if my property is in a very high or high fire zone? Thankfully, you can depend on the NHD company. We all use NHD companies. They will tell you. Well, that's good. You can't just simply say, I have no idea what type of zone I'm in. Nope, you have to figure it out because you have to give the form to the buyer. Okay. The next question you have to figure out when you're if you're in a high or very high is, when was the house built? Here it matters. Because if the house was built after January 1st, 2010, the fire hardening part of the fire hardening defensible space form is not required, but the defensible space part is still required. So once again, a seller cannot say, I have no idea when my house was built. No, you have to figure it out. Okay. But then there are the questions. Up until a couple months ago, there were 6 questions along the lines of, there were 6 questions. One of them said, do you have a wood roof? One said, do you have single pane windows, non-tempered glass? One of them said, do you have combustible gutter covers? And I was asking the seller, do you have any of these 6 things that you shouldn't have for fire safety, wildfire safety? So I've always told sellers, when in doubt, say, yes, I do have those bad things. It's better to say that and be wrong than say, nope, I definitely don't have a wood roof, and then you do have a wood roof. Then you're in trouble for bad disclosure. Okay, you got that. But now there are 12 questions right under that that are basically the opposite. They're basically asking the seller, have you done this recommended retrofit to your house to make it safer from flying fire embers? Have you put in a certified roof? Have you put in dual pane tempered glass windows? Have you put in particular type of vents, particular type of gutters? So I'm telling people, when you're answering those questions, err on the side of saying no. If you're not sure if you've put in this particular special type of vent, say, nope, I haven't done it. If it turns out you have, buyer's going to be pleasantly surprised. Wow, I thought they didn't have it. Now they do. I know what you're saying. The questions are you aware? Can't the seller simply say, I'm not aware. I don't know what kind of vents I have. Yeah, you can. But then buyers sue you and say, she must have known. I can't believe she didn't know. I don't believe her that she didn't know. You know what I'm saying? Even though the questions say, are you aware? It's not that simple. So anyways, there are 12 new questions. That has happened. All right. So now I've told you what has happened. Then we get to the defensible space part. Have you ever noticed on the defensible space part of the fire hardening defensible space form, the first question is there a local ordinance that basically supplements the California law on defensible space? And that's another question where the seller can't say, I got no idea. No, that's when you have to know the answer to. Well, who are they going to depend on to answer that question for them? You. They're going to say, does Bakersfield or Kern County have a local vegetation management ordinance? Let me ask you a question. Does it? I don't think it does, right? You guys should. If you don't know, nobody knows. So, pointing at Jeannie. I'm pretty sure there isn't one. And you can ask your NHD company. So your sellers can safely answer that question, no. Have you seen what the next question is in the form is? Does this house comply with the California defensible space rules? But this is another are you aware question. So the seller can simply say, I do not know. And that's a legitimate thing to say. Of course, remember what I said the first thing. If it doesn't comply, you're vulnerable to a random inspection. But at least you're not violating any disclosure law by simply saying, I don't know. Okay? It's so complicated, this form. Yeah.
Okay, so there is some kind of law that, I mean, the fire department goes around, and if your weeds are too high, it's a bunch of dry,
maybe there
all
is
that.
something.
Is that the same thing?
That's what I'm talking about. Okay. Then that probably, I'm not even 100% sure if that fits into the category, but I think it does fit into the category of vegetation management. I don't know. Okay, you guys can figure that out on your own. It's a local thing. But the point is the seller does have to answer that question. Okay, now let's talk about the law sitting on the governor's desk. Right now, the California law has the defensible space requirement. If you've ever looked at it, it's in the Public Resources Code. There's the 30-foot rule and the 100-foot rule. So within 30 feet of the property, you can have a certain amount of vegetation, and then between 30 and 100, you can have a little more vegetation, and beyond 100, you can do whatever you want. There's a proposed law sitting on the governor's desk that would create a new category of 0 to 5 feet. A new ember-resistant area where you can't have anything. You can have no vegetation at all within 5 feet of the property. let's say the governor signs this law. It does not take effect immediately. It basically takes effect, first the Department of Forestry has to come up with regulations defining more specifically what this Zone 0 means. And then informational guidebooks have to be created for consumers. And until that is done, then there's nothing has changed. Well, let's say when this, and we're predicting the governor will sign this, and we're predicting all of this will be done maybe towards the end of next year. When that happens, is it going to change your life as a realtor? No. It's just going to change the homeowner's life because they're going to have stricter standards. They're not only going to have to comply with the 30-foot rule and the 100-foot rule, they're going to have to comply with the 5-foot rule. But guess what? It looks like this 5-foot rule is not just going to apply to residential 1 to 4. It's going to apply to pretty much all buildings. So that doesn't mean this form that I keep talking about is going to be required. The form's not going to change. The form's probably going to mention this on the form, but it's not going to require people to fill out the form differently because there's still that question, is your property in compliance with defensible space rules, which the seller can still answer, I don't know. So I know it's kind of complicated, but we'll explain all this in the handout you're going to, in more detail, the handout you're all going to get on Monday morning if the governor signs a law. And by the way, the requirement to comply with the 5-foot rule, even once all this happens, you don't have to comply for 3 years unless you're selling. If you're selling, so let's say the law gets passed sometime next year, the regulations are done, and the guidebooks are out. That will mean from that moment, seller, you have 3 years to make sure you comply with that 5-foot rule. But if you're selling, you have to comply now. But it doesn't say you have to comply before close. So it's not a point of sale. It's you have to comply because you're selling. Well, if I have to comply before I'm selling, but I don't have to do it before I sell, that makes no sense. I think that's going to be interpreted like the current law says. You know how the current law says if the seller doesn't do a defensible space inspection, the buyer has 12 months after close to do it? Have you ever read the fine print on that form? Do any buyers actually do that? No. Does anybody check? No. I doubt anyone's going to check on this one either. So the real thing we're going to take away from this, if the governor signs it, is there's going to be a new 5-foot amber-resistant zone around all residential properties, not just 1 to 4, where you pretty much can't have any vegetation at all. But we don't even know that 100% until the regulations come out. So we know nothing, basically, at this point. So, but just stay tuned. This is more of stay tuned, okay? Well, the question is, remember, you can rely on the NHD. You can rely on the NHD to tell you if you're in a zone, if you're in a very high or high fire zone. My experience is you can usually rely on the NHD company to tell you if there's a local vegetation management ordinance. But you cannot rely on the NHD company to tell you if your property is in compliance with any defensible space. The only way to find out for sure if you're in compliance is to call out the fire company or CAL FIRE. They're the only ones allowed to give you an official certification that you're in compliance. And you know there are private companies out there. We even have it on our purchase contract, a reference to, you can order a wildfire disclosure report through your NHD company. It's a good company, I recommend it, but they're not official. They're not officially telling you you're in compliance or not. The only people that can do that is the fire company or CAL FIRE, and there is no mandatory, contrary to what some I was in Newport Beach, I was in a couple other places, where the fire company's out there telling consumers, you can't sell your house unless you call us first so we can do a defensible space inspection, and that is false. Unless you live in a city where there's a local city ordinance that requires a defensible space inspection before close. There are some cities, every single one of them is in Northern California. That one I can guarantee. So obviously this is a complicated sort of area, but that is the latest. All right? Yes. She doesn't need a mic.
Yeah, in Kern County,
Yeah.
an AB 38 isn't required by.
Right. In other words, you probably have one of those fire companies that are out there telling people, you can't sell here until you call us first.
No, that's not true.
They don't say that.
No, on the NHD report,
Yeah.
it's a higher verify,
Yeah.
AB 38 is required.
But what do you mean by AB 38 is required?
Certificate of clearance, you have to call CAL FIRE. If it's not in their zone, they have Kern County Fire come out and issue the certificate.
It's not required.
It says on the NHD it is.
Well, the NHD's wrong then. Seriously, I mean,
It says AB 38 certificate is required.
then talk to whoever NHD company is telling you that. Talk to them. I talk to them all the time. It's not. It's not required. I mean, when we look at it, of course it's required. You have to be in compliance. One way to look at it is every single homeowner should call the fire company to make sure they're in compliance so you don't get in trouble if they audit you. And in some areas, Big Bear, for example, they do come out every year. So in Big Bear, I tell people, get it done because they're going to come out and cite you anyway, so you might as well do it. But there is no, I'm glad you brought that up, so I can reaffirm there is no mandatory point of sale requirement to do it anywhere in Southern California. Anywhere. I guarantee that. So that's one thing I can guarantee. So I'm glad I raised that because I run into this everywhere. It's really an issue. But then I don't want to say don't do it because I would want to know if my house is compliance because I don't want to get fined when they do show up unannounced. Yeah.
On any of these, if within the
Yeah.
0 to 5 vegetation,
Yeah.
everything, what if your neighbor has a huge tree
Yeah.
that's within this 5 feet?
Sue your neighbor.
But I'm the neighbor.
You're the neighbor. You're going to get in trouble.
Snitch on them.
And by the way, you know what's crazy? This applies to condos, which is crazy. So I live in I rent a condo and I own a condo. If I were selling, the one I live in is actually in a high fire zone. So I'm required to fill out this form, but of course, the HOA should be required to fill out the form. I don't know anything about the construction of this thing because it's not even owned by me. And I'm not responsible for the defensible space because that's the HOA's response. I'm not in charge of the vegetation. This should be exempt. Condos should be exempt from this. Planned unit development should be exempt from filling out this form, but they're not. Crazy, yeah.
This probably will come
Yeah.
later when more information
Yeah.
comes out, but what if in that 5 feet or 10 feet
Yeah.
or 20 or any of the feet is a protected tree like a redwood?
That's an
Then-
exception.
Okay.
But you're right. Will that be an exception in the 5 foot? Because it's definitely an exception in the 30 foot and the 100 foot. Stay tuned. I keep saying that. Stay tuned. Stay tuned. All right, let me go on. Let's talk about some laws that other laws that the governor actually did sign. Speaking of the HOAs that we all hate, this is actually a good law for people who hate HOAs. There's a law the governor did sign, and it took effect immediately. It's effective right now. That says if you live in an HOA and you violate the rules, you know, HOAs have all sorts of rules. Some are in the CC&R, some are just in the rules, bylaw, whatever. There's a rule, and you violate it. There's a new law that says you can, the monetary fine against you can be no more than $100, which is a big deal. Because prior to that, you could like, okay, there's a rule that you can't paint your garage this color, it's got to be this color. And up until whenever this happened about a month ago, if you had your garage painted the wrong color, they could fine you $5,000. They could fine you $10 million. They could fine you whatever they want to fine. There's no restriction. Or the swimming pool, you can't use the swimming pool after 10 o'clock. Oh, you're in the pool at 10:15, $600 fine. I mean, there was no restriction. Now there's a $100 limit on violate. Of course, that leads to the question, my garage is painted the wrong color. Tomorrow it's still painted the wrong color. can they fine me $100 tomorrow too? And the answer is probably. So you can't just let it go. Say, well, somebody could say, I like that color. It's worth $100 to me to keep it that color. You know what I mean? I don't think you're going to be able to get away with that. Plus, the law also says if the violation that you're guilty of affects the health or safety of other people who live there, there's no restriction on the amount of the fine. Plus, obviously, I hope it's obvious that if what you did wrong damages common area or damages your own unit, that's the HOA's responsibility, you have to pay the cost of fixing it. That's not a fine for violation. That's a cost of repair to fix the thing, the damage caused by your violation. But simply doing a violation doesn't affect health or safety of other people, doesn't damage anything, that's when there's a $100 limit.
Would that include if you painted your house purple and it damaged the value of the neighborhood?
Good question. This is why we have judges to make those types of determinations. Be the test case, see what happens. You never know. You never know. All right, but that's the latest on that. All right. Has the governor signed any other new laws that you'd be interested in knowing? A couple. Let's talk about, we also got to talk about rentals for a little while. And there are two laws that the governor just signed regarding rentals. One you'll be more interested than the other. I'll start with the less interesting one. There's a new law that says if the tenant's security deposit was provided to the landlord when they moved in electronically, when they leave, the presumption is they get refunded the security deposit electronically. Unless it says in the lease very specifically, no, tenant and landlord agree the refund will be in the form of a check. This is not a big deal, but our lease is going to have language in there to reflect what I just said, okay? It also says, though, that, when you move out, the landlord has 21 days to notify you either we're giving you back the whole deposit or we're deducting some of it. That notification, the law says, that still has to be in paper. That can't be electronic. And then it also says if there are multiple tenants who are leaving, the landlord should send one check by paper to everybody. But individual tenants who made the deposit electronically, the presumption is the refund they get is also electronic. I don't think this is a big deal, but it's worth mentioning. Remember what I told you, I'm sure I told you this last year just to remind you, that there's a big new law in effect on rentals now regarding security deposits that basically says when a tenant moves out, if you want to deduct from their security deposit for cleaning and repairs, which is the main reason you usually get a security deposit, you better be able to support with before and after photographs. So let's say, for example, I have my rental property in Culver City. Let's say my tenant moved out, so I get a new tenant. Right before they move in, I have to take pictures of the unit and the outside. Then, a couple years from now when they leave, I have to take more pictures the day they leave. And then assuming they've damaged the property, I'm going to fix the problem and then take more pictures. So within 21 days after they leave, I'm going to send them a notice, yeah, I'm going to deduct $800 from your security for the following things. I don't have to do that work within the 21 days, but I have to tell them. But then let's say a couple weeks later I finally do the $800 of repair work. I'm going to have to send them at that time, not just invoices if I hired someone else. I'm going to have to send them 3 sets of photographs. The photographs I took before they moved in, the photographs I took right when they moved out, and the photographs after I did the work. So they can see this is what it looked like before you moved in, this is what it looked like the day you moved out, this is what it looks like now after I fixed it. So they're going to have, if I don't do those 3 sets of pictures, I cannot deduct from their security deposit for cleaning and repairs more than $150. Now, what about my existing tenant who was there before July 1st? Well, obviously, I don't have the pictures before they moved in. Although I've always recommended that as a good, I didn't do it myself, of course, dumb me. But the point is, for those people, when they move out, I'll have to take the pictures when they move out and after I do the work. So there'll be just 2 sets of pictures. But any new tenants since July 1st, you better have taken the pictures before they moved in. So what if any of you are asking yourself right now, I have a tenant, they moved in after July 1st, I didn't take the pictures when they moved in. You're screwed. You're not going to be able to, they could completely trash the place and you'll only be able to deduct $150 out of the security. The good news is you can still sue them for any damage they caused, but you'd have to give them back the whole deposit minus $150, then sue them for whatever they did, but you won't be able to take it from the security, okay? So that was a law that took effect July 1st, but I told you about it last year just in case you didn't know, okay? All right. Here's the really big one. You're going to love this or hate this. Significant law the governor just signed a couple days ago applies to all rental property, residential rental properties that says, get this, landlord, you have to provide for your tenant a functioning stove and a refrigerator. Don't complain to me. In other words, I bet you probably thought the law already required you to supply a stove. It didn't. You've always been required to have a functioning bathroom and a heat source, right, and sinks and stuff, but you were never actually required to supply a stove with the rental. Pretty much everyone does. Now it's required. But the refrigerator is a big deal. Because I don't know, a lot of, I would say maybe a majority of rental properties don't supply a fridge. The tenant does their own. So you've already got a bunch of questions. Let me mention a couple things and then I can go to your questions because I may answer them. You could, in the lease, I see you. Yes.
Can it be
Mr. Impatient,
a mini
yes.
fridge like in the hotel room?
See, that's what I was gonna mention. The law does not specify the size of the refrigerator. I would not be surprised if between now and January 1st, when this takes effect, that they clarify that. I suspect the intention was a full-size fridge, but it doesn't say that. The way the law is written right now, there's nothing stopping you from putting in the mini fridge and complying. But let me say this. It is also okay for the landlord and the tenant to agree in the lease that the tenant's going to be the one to supply the fridge. So, in other words, what we have to do on our lease form is there's going to be a new paragraph that says, California law requires the landlord to provide you with a refrigerator. However, if you want to supply your own refrigerator, check the box. So the tenant will be able to check a box saying, I'll supply my own. And why would they do that? Maybe because they already have a good one and they don't want the landlord's mini fridge. So that's a distinct possibility. January 1st. Does not apply to your existing tenants unless you renew them. Okay, so I have an existing month-to-month tenant. That can go on forever. You don't have to do anything. If that tenant moves out, of course, then you have to put them in. Let's say you have an existing tenant on a lease. The lease is over in May. At the end of May, you want to renew the lease. At that point, you have to put in the fridge. What if at the end of May, you don't renew the lease, you just let it go to month? We read the law as saying that doesn't trigger it. But if you renew the lease, that triggers it, okay? So, but here's the big question that we honestly don't know the answer to, and what we need trying to get clarification is, can a landlord say to the tenant, the rent is $1,200 if you have a fridge, it's $1,300 if I have to supply the fridge. Can you give a tenant a financial incentive? And we don't think you can because we think this is going to come under the category of habitability. And if it's a habitability thing, tenants can't really waive the right. You can't say, I'll give you more money. The rent is less if you don't have a bathroom. You can't say that, right? You can't. Tenant says, I'm going to save money. I got my own, portable thing here. Even if a tenant is willing to say that, I would say, don't do that. So we're thinking, the way this law is written, it's basically expanding mandatory habitability requirement. So we're saying, unless we get this clarified, you can't give a tenant an incentive to have their own refrigerator. Here's when you can do that. Landlords do not have to allow pets, for example. You have to allow emotional support animals. But if a tenant has a pet, you can say no pets. Or you can say, you can have a pet, but your rent is $500 more than otherwise. So you certainly can do that. But when it comes to a habitability issue, you can't really, if you do this, the rent is this, if you do that. Okay? Yeah. Gene.
I just want all of our Realtor members to know, just want you all to know, all of your legislators that work for us all voted no on this bill at our request.
Yeah.
Doesn't mean it didn't get to the governor's desk,
Right.
but they all voted no at our request.
By the way, you guys, with your money that you pay, we killed so many bad laws this year. I should probably tell you those. I mean, there were so many. This one got through. Occasionally they get through. But there was going to be tremendous expansion of rent control, and the Tenant Protection Act was going to apply to single-family homes, et cetera, et cetera. So we had a very successful year, which is why I'm not telling you many new laws, as you've noticed. I've told you like 4 laws, and that's about all I have to tell you. But this is a significant one. Speaking of that, just a quick reminder. Remember, you all know this, but it never hurts to periodically remind people who sometimes have not heard this. We've got statewide rent control. It's called the Tenant Protection Act. It applies everywhere in California. I don't care if you're in a rent control city like LA. I don't care if you're here. It doesn't matter. The Tenant Protection Act says for all rental properties, residential, with 2 or more units that are at least 15 years old, where the tenant has been living there at least 12 months, in those rental properties, you are limited on how much you can increase the rent, and you can only evict for certain reasons. Single-family homes, you can increase the rent as much as you want, unless you're currently in a state of emergency, like there is one still in LA, Calaveras, and Tuolumne. But you don't need a reason to evict a tenant from a single-family home. You say to the tenant, you have to leave. Why do I have to leave? You can say, number 1, none of your business. And number 2, if you really want to know, you're kind of boring. I want a more interesting tenant. You don't need a reason. But that's also true for rental properties that are less than 15 years old. And it's also true if the tenant in question has only been there less than 12 months. That's why I always tell people, be careful on your rentals, because once they've been there 12 months, they're your tenant for life. Well, can't I still evict someone who's been there more than 12 months? Well, yeah, if they violate the rules, they don't pay the rent. But you can't just evict them because you feel like it. Unless there are basically 3 ways to evict those tenants. Number 1, you're selling. Number 2, someone in your family wants to move in, or you do. Or number 3, you're doing a substantial remodel that makes the property not habitable for 30 consecutive days. But if you don't want to sell, you got no kids or grandkids to move in, it can't be a nephew or a brother, and you can't afford to do a big remodel, as long as that tenant keeps paying the rent, they're your tenant forever. And you're limited on how much you can increase the rent. You can increase it each year by 5% plus the inflation rate for your county, with a cap of 10. They just came up with the inflation rate for Kern County, and it's 2.7, so the total is 7.7. So if any of you have one of these properties I talked about, and you want to increase the rent on your tenant, don't increase it more than 7.7%. But by the way, single-family home, you can do whatever you want, but you have to give those tenants the form, right? The RCJC, the rent cap just cause addendum. If you don't give them that form to sign it, then the single-family home tenant can stop you from a rent increase. Nothing I just said is new. The only new thing I just told you is the new number as of August 1st in this county is 7.7. Okay? All right, we're almost done. Other things you really need to know about. There's one federal thing. Well, first of all, I'm going to finish up with forms. And I'm going to mention buyer broker. I got to mention buyer broker because there is a couple new things. Before I get to that, so two more topics. First one is there is a new form. You've probably seen it. If any of you have opened up the RPA in the last 2 weeks, you've seen a new form attached called the Federal Reporting Requirement Purchase Addendum. Up until a couple of weeks ago, there were 6 forms attached to the RPA. The agency disclosure, the dual agency form, the wire fraud advisory, the fair housing form, the privacy form, and the buyer inspection advisory. Do you realize none of those are actually addendas that have to be signed by both? The last 4 I mentioned only have to be signed by the buyer. And the agency form only has to be signed by your client. And probably when you took the listing, you gave the seller the 2 agency forms. And probably as the buyer's agent, when they signed the buyer broker, you gave them those 2 forms, so you really don't even need them. But this new attachment to the RPA is an addendum, meaning buyer and seller both have to sign it. What is this form all about? Okay, you've probably never noticed this, but for many years there's been a very small paragraph in the purchase contract, 13E, that says, more or less, it says in certain circumstances, if you're paying all cash to buy a house as an entity, you have to provide certain information to the title company so they can provide it to the federal government. We call this the anti-drug dealer law. Here's the idea. Criminals, not just drug dealers, but criminals who accumulate a lot of cash illegally, they want to launder that cash. One way to launder the cash is invest in real estate. Buy a house. Take the drug money and you buy a house. You don't have drug money anymore, you have a house. Now, if you make a big down payment and then get a loan, lenders are required to look at this stuff. Lenders are required to suspect you of being a drug dealer. They're supposed to look at where you got this cash, and they have a reporting requirement. So the drug dealers figured out it's better to pay all cash. If there's no lender involved, no one's checking to see where this cash came from. And the drug dealers say not only is it better to pay all cash, but it's also better to buy it in the form of an entity, corporation, LLC. So we're not even providing our real names. So we're hiding behind the entity and we're paying all cash so no one scrutinizes our money laundering. Government figures this out, so the government says, okay, entity purchases all cash of residential real estate, and they came up with a number of 300,000, and those deals, there is a reporting requirement that the escrow company has to tell the federal government, Department of Justice, who the real people are behind the entity. You guys have never cared about this. You know why? Because this law only applied in certain counties. LA, San Diego, San Mateo, San Francisco, Santa Clara. Apparently there are no drug dealers anywhere else. Okay, so the rule just changed. The change in the rule, which takes effect March 1st, is this now applies, number 1, everywhere in America. Number 2, it applies to all cash entity sales of any price, not over 300,000. Number 3, it applies to purchases of vacant land that can be used to build residential property. And number 4, it doesn't just apply to entities, it applies to trusts. So an innocent person, not drug dealer, wants to buy a house all cash using a trust, in the name of their trust, they're going to have to, the escrow company is going to have to report to the federal government the people behind the trust, the trustee and any beneficiaries, their date of birth, their street address, their DBA, their taxpayer ID number. Plus, crazy enough as it seemed, they're also going to be required to get that information from the seller. So the innocent seller selling to the drug dealer, the federal government's going to want your date of birth, taxpayer ID number, street address. Now, number one, most innocent people probably don't care because they've already got that information probably somewhere. So maybe this won't be a big deal. But I could just see some sellers saying, when you tell them this, I'm not going to sell to all cash people because I don't want to give up this information or whatever. So this form that is now attached to the RPA, number one, it explains what I just said. And number two, there's a place at the bottom for the buyer and seller to sign. By signing, the buyer and seller are saying, we agree that if necessary, we will provide to escrow any information they want from us in order for escrow to comply with this law. And escrow has to comply with it. If escrow doesn't provide this information, the deal can't close. So at some point before March 1st, I think your escrow companies are going to start requiring this form. Of course, some buyers and sellers are going to say after reading the form, well, I'm not paying cash, I don't need to sign this, right? I think that's true, unless the escrow is going to be real conservative and say, well, how do we don't know in the middle of escrow you're going to change from a loan to cash? That never happens, does it? It really doesn't. You see cases where people start off as cash and then they change to a loan. Very rare do they start off with a loan and convert to cash. But if it is an all-cash sale, the buyer says, yeah, it's an all-cash sale, but I'm not a trust or an entity. The escrow company might say, yeah, but in the middle of escrow, you may assign your interest to your own LLC or your own trust, which happens. So we'll see how it plays out. The form is already there. And if your clients ask you, do I need to sign this now? Technically, no. Can't hurt. I mean, like I said, if I were a buyer, I'd honestly sign it. I don't care about the federal government knows my date of birth. Or they probably know it anyway. Or my taxpayer ID number. I'm not hiding anything, blah, blah, blah. By the way, if you have a client and you give them this form and they read it and say, I don't want to buy this house, they just told you they're a drug dealer. Anyway, so by the way, the escrow industry and the title industry have filed lawsuits against the federal government saying bad law, illegal law. If they're successful, it'll never come into effect. So maybe before March 1st, this will go away. By the way, if it doesn't go away, the Forms Committee is going to get rid of this form and incorporate it into the purchase contract to make it longer. Right. So when they did this, I said to the Forms Committee, does that mean the purchase contract is going to go from 17 pages to 18 pages? And they said, no. Have you noticed on page, I think it's 15, there's some gray area there? They said, we're going to put it there. This is not going to make it go beyond 17. Which disappoints me because I was hoping before I retire it hits 20 pages. A nice round number, You know the day I started 40 years ago, it was 2 pages? Who's older than me and remembers the 1-page form? Okay, you're not older than me, but you've been doing this longer than me. Anyway, that's the latest. Okay, last topic, buyer broker, the latest. Okay, like I said, it's been 13 and a half months since D-Day. On D-Day, 2 things happened. You guys agreed to do 2 things. Number one, you all agreed that if you're going to work with a buyer, you're not going to, quote unquote, work with a buyer until they sign a contract. You've always done that with sellers. None of you would ever work with a seller without a listing. But you always worked with buyers without a written contract. That changed. When I say work with a buyer, what does that mean? Clearly, it means you can't show a house without a buyer-broker contract. But it's really interpreted to be even beyond that. So it's like, if you want to give a buyer, a prospective buyer, general information about real estate, recent sales, houses currently on the market, you can do that without a contract. But if they ask you for specific information on a particular property, like a market analysis, that triggers the requirement. And showing the property, definitely don't show without a buyer-broker contract. Okay, but that thing you all agreed to on D-Day only applied to residential. So between last August and January 1st, nothing had changed at all regarding commercial, land, industrial, or farm buyers. Then on January 1st, California passed a law that said no matter what type of buyer you're representing, you need a buyer-broker contract. But the California law said you don't need the buyer-broker contract until you write the offer. And that's the law today. So if any of you work with non-residential buyers, you can show them without a contract. Of course, to get paid to write up the offer, you need a contract. So here's the update. A regulation has been approved and is going to be probably become effective. We don't know, it could be November, it could be December. This regulation is going to say that in California, no matter what type of property it is, don't show it without a buyer broker. So today you could show a commercial without a buyer broker. That's going to change pretty soon. Okay. The other thing this regulation is going to do a couple other things. Another thing it's going to say is, you all know, I think, that a buyer-broker contract can only be for a limited period of time. How long is that? 3 months, you're right. The regulation is going to change that to 90 days. Which is a big change because you guys are going to have to start being able to count days. Because right now, October the 9th, if you signed a buyer-broker contract, it could be good until November, December, January 9th. When the reg kicks in, then it would have to be, if you count the days, I think it would be January 7th. This is important, though, because did you know that if your buyer-broker contract is 1 day off, it's void? You could do, and you do it, you innocently do all the work, help the buyer find the house, write the offer, close the deal, you don't get paid, unless they figure it out. This doesn't apply if your buyer is an entity. There's no limit on how long buyer-broker contract can be with a corporation or LLC or something, but for individuals, so 3 months changing to 90 days. Be careful about that. Okay. Third thing. Can you renew a buyer-broker contract? Of course you can. The new reg is going to say to renew a buyer-broker, the renewal has to be signed before the first one expires. You can't like, oh, it expired Monday, here it is Friday, let's renew it. You had to renew it before Monday. And you can only renew it for 90 days at a time. However, I started thinking about this. You miss the renewal date, just do a brand new one. You know, same thing. So that's not a big deal. Okay. Couple more things. One more big thing is the new regulation is clarifying what has always been true, but I hope you know this. When I say you can't show without a buyer-broker contract, what I really mean is you can't show as a buyer's agent. But if the property being shown is your listing or a listing by anyone in your brokerage, you work for a big company, that could be a lot of listings, you can show that to a buyer without a contract. So you got to sign up, it's your listing or it's your company's listing. Someone's visiting Bakersfield for the day, they see the sign, they call you up, hey, I see this house, can you show it to me? Sure, let's meet at the property and meet them there. Of course, you maybe try to convince them at that time to sign a buyer-broker contract. But they may say, I just met you 3 seconds ago. I don't want to sign a contract. You can still show it to them because it's your listing. Now, if they call you up and they want to see other properties, say, I don't like this one, but could you show me some others? Now, hold on, you need to sign this form. But you can show your own listings. By the way, there's a solution to the situation when the buyer you just met wants you to show them things, but is reluctant to commit to you for 90 days and agree to pay you whatever. We have sort of a short form version, the PSRA. So generally we talk about the BRBC, but we have a short form PSRA which basically on that form you can basically say to the buyer, tell you what, how about you agree that I'm your agent for the next 3 hours with respect to this house only. And you know what? You don't even have to pay me. Even if you buy this house that I show you in the next 3 hours, you don't have to pay me. I mean, if you're willing to do that, and they're willing to do that, you have satisfied the obligation to have a buyer-broker contract in place. It doesn't protect you at all. I mean, but the idea being you would do this, show them the house, get to know them. By the end of the day, they're like, I like you. Then let's commit to each other and let's sign a real contract with money in it. Okay, so same exact thing with open houses. Do you need a real estate license to do an open house? Only if you want to talk. Okay, so you probably want to talk to the people that come in, so you need a license. But not only do you need a license, talking to someone at an open house is considered a showing. So you need a buyer-broker contract. But once again, if it's your listing or a listing by anyone in your company, you don't need it. And even if it's not your listing, bring some PSRAs to the open house. So if they come in and they want to talk about the house, you can't talk to them unless it's your listing, unless they sign a buyer-broker contract. But you can have them sign a PSRA. They probably should be willing to do that. Yeah.
Does the open house visitor non-agency form take that requirement
No,
away?
it doesn't.
Okay.
And I'm glad you raised that. So there's another. So the issue is, let's say it is your listing. The open house is your listing. So you don't need a buyer-broker contract. We have another form. This form serves a different purpose. So if it's not your listing, the form you need is the PSRA or the regular BRBC. But if it is your listing, I just told you, I don't need any form, right? You don't. But paranoid us, to avoid you getting in trouble, we want you to give a form to the buyer, to the visitor to the open house called the OHNA, the Open House Non-Agency Sign-In Form. That form, the visitor is indicating, I understand that this nice person who's helping me is not my agent. So what we're worried about, and this actually is a serious thing to worry about, is someone saying, well, I went to this open house, and she helped me and answered all my questions. She led me to believe she was my agent. And isn't that a violation? Shouldn't she have made me sign a buyer-broker contract to do that? And the response is, no, because you understood that I was helping you as the seller's agent. I didn't understand that. Well, that's why you haven't signed that form. So the form is not required, but we recommend it to protect you from that type of situation. Okay? So that's the latest on the buyer-broker contract. Yeah. Yes? I'm going to get to that.
And the other one was, if people have some companies
Their own, yeah. It could be okay, or it might not be. We don't guarantee, like I think Zillow has a showing form that's not good. We don't think it is good. But there are individual brokers can come up with their own showing forms, and they might be okay and they might not be okay. We can't guarantee. You can send it to us. We'll look at it. You have a question? Or you're fixing the mic? Okay. So that was part one. Remember, there's one more thing I want to talk about. So that's the latest on buyer-broker contracts. But the other thing that happened on D-Day was even bigger. And that was you agreed to change the way you got paid. And that was the revolution. Okay, getting them to sign a form, okay, I can handle that. But revolutionary change was compensation to buyer's agents, the whole process completely different. In the good old days prior to D-Day, it was very simple how you got paid as a buyer's agent. You looked in the MLS, the listing agent was offering you some money, that's what it was. That's what you got paid. No form needed to be signed, no negotiation required. Boom. Offer of compensation by listing agent, that's what you got paid. That changed completely. Now, how do you get paid as a buyer's agent? It's a two-step process. Step one, the most important step, which is the revolutionary change, is your buyer has to decide how much you're getting paid. You notice I didn't say your buyer is going to be the one to actually pay you. That's rare. The new normal, of course, is you write in the offer, you check paragraph 3G3, and you ask for the seller to pay the buyer's agent in the form of a credit. And it's working, it's happening. Sellers are not unfamiliar with the concept of credits. Your whole career you've been asking sellers to pay for the title fee, the escrow fee, the transfer taxes, the NHD fee, the HOA fee, and maybe some repairs. The concept of a seller credit is nothing new. There's just one more now. It's seller pays buyer's agent. But the key thing to remember is the amount that you're going to get paid is determined by your client. What I'm really saying is, and by the way, when you guys are having group discussions, you know this antitrust rule, you can't start using numbers. As your lawyer, I can use numbers. Okay, so just want you to know that. So I can make up numbers. So for example, you negotiate with your buyer on the buyer-broker contract that you're going to get paid 2.5%. Turns out the seller is willing to pay you 3%. Too bad, you get 2.5%. In other words, or your buyer wants to buy a new house, and the builder in question is offering a 3.5% referral fee. You get 2.5%. You can't get paid more than your buyer authorizes you to get paid. So you have to have this discussion with the buyer. And if there's any possibility they're going to buy a new home, research what the builders are paying and make sure your offer is at least that amount is there. And you can explain to your buyers, you're not the one who's going to be paying me. You're not going to write me a check. Just like you're not going to write a check for the title fee or the escrow fee, or you're not going to write a check for the transfer taxes. It's going to be worked into the paperwork. Okay. Of course, in reality, if the buyer agrees to pay you 3% and the seller's only willing to pay 2%, the buyer does owe the difference. They will have to write you a check. And what if the buyer says, I don't want to write you a check? Then you're going to say, you're not going to buy this house. In other words, you can prevent the deal from closing by the fact that you're not getting paid the total amount. Of course, in reality, sometimes you're just going to say, fine, I'm a saint. I am going to not make you pay the difference. But you're used to doing this as buyer's agents your whole life. You've kicked back money to your buyers at the last minute. You buy them the refrigerator or whatever. You're used to that concept. But you don't have to, of course. I mean, sometimes the buyer will say, well, we're paying this amount, and the seller countered. They only want to, I asked them to pay you 3%, but they're only agreeing to pay 2%. What does that mean? You say, it means you owe me 1%. And what you really tell them is, what the seller is really saying is, it's not that they don't want to pay me 2%. They're not getting enough money to justify that. I don't think the seller ever really cares how much the buyer's agent is getting paid if they get enough. I mean, if I were the seller and you were my listing agent and you brought me 3 offers, one of them asked me to pay the buyer's agent 2, one asked me to pay the buyer's agent 3, one asked me to pay the buyer's agent 4, that means nothing to me. I'm going to say to you, give me a net sheet on all 3. considering all the credits and the price and everything, at close of escrow, what am I going to get? And you tell me, well, guess what? The one where they want you to pay the agent 4% is going to result in $20,000 more for you. I'm going to say sold. In other words, I'll pay the buyer's agent. If you offer me $1 million over the list price, I'll pay the buyer's agent 25% commission. Buy her a car and pay for her kids' college. Of course, all of that would have to be on the buyer-broker contract. But anyway, so you see what I'm saying? So the point is, I'm always a little bit confused now when sellers counter, I only want to pay your agent this rather than this. The counter should be, you need to increase your price. Because if the buyer increases the price, the seller will go for it. Anyway, the point is, getting back to this. Okay, so I'm finally building up to what has changed. So the buyer contract, you agree to pay, buyer agrees to pay you the number. Okay. And then, oh, by the way, the other situation is when you don't want to, you know, this happens rarely, but sometimes where the buyer, you know, they write the offer, seller pay my agent 3. Seller counters. Either they counter, we don't want to pay the agent, or you need to increase your price in order so we can pay the agent. And the buyer says, well, I can't afford that. I can only afford, that's all I can possibly afford. I cannot, if the seller won't pay you the full amount, I can't pay the difference. And then they look at you with their big eyes and they say, but this is my dream house. So if you make me pay what I owe you, I can't buy my dream house. Are you really going to stop me from buying my dream house? And you're going to say, yes, that's exactly what I'm doing. The way I would say it is, so in other words, you want to buy a house that's out of your price range at my expense. Of course, they're going to say, yes, that's exactly what I want to do. That's what I'm asking. And then you have to decide how you respond to that. But okay. One more thing I want to talk about is, so we all know, I hopefully have made it clear, you as a buyer's agent cannot get paid more than your buyer agreed to pay you. I don't care what the source is, the seller, the builder, whatever. You can't get paid more than what the buyer agreed you should get paid. So the question is it the listing agent's job to verify this? In other words, you're the listing agent. Buyer submits an offer. Buyer's offer asks your seller to pay their agent 3%. Is it your job as a listing agent to demand to see the buyer-broker contract to make sure that their buyer-broker contract is that full 3% rather than a lower number? And the answer is no, it is not your responsibility. And we've tried to make that clear now. It used to say on the purchase contract, 6 months ago, it said, upon request, buyer will provide buyer BRBC. Then it didn't say that. And then for a couple of months it said, buyer represents that they are not asking for a credit that exceeds the amount that they agreed to pay their agent on their own form. It doesn't even say that now. All it says is seller will pay buyer's agent X. There's no comment on anything else. In addition, the listing contract now says specifically, listing agent will not be verifying the buyer's agent's compensation on their form. This is trying to make it clear to you that you're not the police on this. Now, of course, don't walk away from this and saying, Gov said it's okay as a buyer's agent to violate this because the seller doesn't have to check. Don't do that. As a buyer's agent, if you do get paid more than your buyer authorized, you can get fined by the MLS, sanctioned by the DRE, sued by an attorney. Don't do it. But the listing agent isn't the police. I don't want you to think some listing agent says, well, I want to see if they even have a buyer-broker contract. Or maybe they backdated the buyer-broker. And agents do all these bad things. They don't even have a buyer-broker contract until they get the deal accepted. They do all these things. They violate the rules. They could get in trouble. But it's not the listing agent's job to be the lawyer police and demand to see the form and read the form and make sure it's okay. I just want to make that clear, okay? And that's reflected on the recent changes to the forms, okay? So now maybe you or your seller does want to be the police. You can always do a counteroffer and say, if you want us to pay this, your commission, we want to see your buyer-broker contract. And if they come up and it's wrong, you could say, well, we're not going to pay that. Does that even help your seller, though? Because then that buyer say, well, then I'll buy something else. And then you lose the deal. It's not necessarily in the interest of your seller to even find out. Once again, I'm not saying as buyer's agents that you can violate these rules.
We have a modification for that form, and I've had to fill one out because I had an instance where I was charging 3, the poor buyer, doe eyes, can't pay it, reduced it to 2.
Right.
Can we reduce it? Can we change it up?
See, that's the issue. Very good question. The answer is no. In other words, I know what your logical response would be. Okay, my buyer agreed to pay me 2.5. Turns out the seller's willing to pay 3. Great. We'll just modify the buyer-broker contract from 2.5 to 3. This settlement says you can't do that. You can only go down. So the initial negotiation is the important one. That's the one where you have to be sure. Yeah, you don't have to. Very good question. Here's how the buyer-broker contract works, right? So let's say you got a 90-day buyer-broker. To get paid, does that mean I have to close in 90 days? No. You don't even have to get into escrow in 90 days. You just have to show it within the 90 days. Then as long as they write a contract during the next, I'm assuming you're always doing a 90-day continuation period following the original 90. You should. Which means to get paid, you have to bring the property to their attention in the first 90, but then make sure you get a contract signed in the next 90. You can close 2 years later. You don't have to extend it for the purposes of it didn't close within the time. But you do have to extend it if let's say you've shown the buyer a bunch of houses in the first 90 days. You don't even have to extend it beyond the next 90 days because you have a continuation clause which covers you. Now, if you're running, but you have to think about this. It's like, who knows if they're going to buy one of the houses I've already shown them? Let's extend it so I can keep showing them houses. So I would say you should recommend it. Another complicated thing is, what about this situation? Remember in the good old days, the question you always asked when you met someone is, are you working with someone? Whereas now the question you ask is, have you signed a contract with someone? I don't really care if you've been working with someone. Have you signed a contract? And then they're going to say, I think so, I'm not sure. Well, figure it out. And then you ask them, yeah, I definitely signed a contract with Joe at the other office. Was it exclusive or non-exclusive? I have no idea. Right, so figure it out. Because if it's exclusive, you have to back off. The Code of Ethics still says you cannot interfere with an exclusive relationship a client already has with somebody else. But then they say to you, but I don't like this Joe guy. I like you. Can I fire Joe and hire you? What's your response now? Your response is, read the contract. Don't go start saying you can, let me show you how. Because that could be deemed ethically violating, interfering with their exclusive relationship. So it's a fine line there. Tell them, read your contract, it'll tell you your rights. Because the buyer-broker contract, unlike the listing form, has a cancellation clause. The buyer can cancel an exclusive or non-exclusive buyer-broker contract. They may have to give 30-day notice. It depends on how you filled that in at the original time. Hopefully the buyer will figure this out, go read their form, say, oh, we agreed that I can cancel you in 10 days. They'll give that first Joe guy a 10-day notice. 10 days later, they'll come back to you and say, I got rid of Joe, now I want you. But don't let Joe accuse you of helping them with that process. because that's still the code of ethics issue. Go ahead.
What if that builder or seller is going to give you a bonus if you bring in an offer? So it's still a note.
It's still going to be deemed your compensation. That one I cannot guarantee. Try that as a test case. Tell us what happened. I mean, it may work. I mean, maybe the settlement doesn't really address bonuses. Maybe. We're always conservative, and we read it as any compensation you get. I could see a judge saying, well, that's not really what they meant, because that's an after-the-fact, unplanned for bonus thing. Maybe that's okay. Conservatively cannot say that it is okay. Okay? So anyway, that's where we are with that. Yeah.
Okay, I'm gonna ask you this, and everybody in here is probably gonna be like, oh, you're an idiot, but I don't really care.
Okay. All right.
By omitting these two forms, I don't see how it can be legal and make sense that with your buyer
Yeah.
signs a form that says, I'll pay you 3%.
Right.
Okay?
Right.
Then you write an offer and you ask the seller to pay you 3%.
Right.
And then if the seller says yes, then what do you cancel that? It makes no sense because it's like you're asking for 6%.
Unfortunately, you don't get 6%, right? I mean, it does say in the buyer broker contract, any amount you get from someone else is subtracted from this. But I know what you're saying. But I think the way you got to look at it is, think of commissions as a closing cost. To buy real estate, we all know the purchase price doesn't pay for everything. There's an escrow company, there's a title company, there's an NHD company, there are transfer taxes, there's HOA disclosure fees, repairs will probably have to be done. There's all sorts of other costs that need to get paid to buy a house. And the buyer and seller can negotiate who pays those costs. And that's all this is. Okay, this is a cost. One of the costs is buyer's agent commission. Another cost is seller's agent commission. You could put in the contract, buyer could say, I'll pay the listing commission. They could do that. Just because the listing contract says seller will pay listing agent doesn't mean the buyer couldn't agree in the contract. No, I'll pay the listing agent. You know what I mean? That's the way you look at it. And the way I look at it, by the way, is buyers pay everybody anyway. Buyers always pay. I mean, where does the seller get the money to pay the listing agent? Do they withdraw it from their bank account? No. Every penny that everybody gets in escrow, including title escrow, listing agent, buyer's agent, every penny, unless it's a short sale, every penny that anyone gets in real estate comes from the money the buyer brings in. So I have always said the buyer pays everybody, including the listing agent. And you know what? If you look at it that way, nothing has changed. The only thing that's changed is you have to convince the buyer of your value. That's the big change. Your buyer has to decide up front what you are worth. Other than that, nothing has changed. The paperwork's different. Now, I know agents, maybe in this room, who tell me, this has worked out better for me. Because in the good old days, I was at the mercy of the listing agent. If the listing agent thought I was only worth 2%, that's what I got. I'm the greatest agent in the world. My buyer agrees I'm the greatest agent in the world. I get whatever the jerk listing agent thinks I'm worth. Now my client, the one I'm helping, they determine what I'm worth. And you know what? Then we write a good offer and we get it paid. If you look at it that way, it's not a bad thing. Yeah.
Another thing is for sale by owners.
Yeah.
You can tell your client now, we can go out and look at everything in town. We don't have to worry about whether they were willing to pay a commission.
Right. Exactly.
You're untying my hands to represent you the best I can.
Right, right. Another good way to look at it, right? I think you got to run over here now and over here. Yes. Let me do him first, then you.
So are we required to provide a copy of the BRBC to escrow and to lenders?
That's a great question. And I was going to ask you.
Because escrow's asking for
Because
those,
in
right.
the old days, in the good old days, for all the years I've worked for you, I was always fascinated by the fact that In the good old days, how did escrow know how much to pay the agents? They just asked the listing agent. Listing agent sent an email, pay me this, pay them that. And the escrow took their word for it. It was a beautiful thing. Pure trust. Now, though, the listing agent doesn't necessarily know how much the buyer's agent's getting paid. Because even if their seller's agreeing to pay $2 or something, maybe the buyer's making up the difference. So to me, logically, escrow should just be calling up both agents. But some of you are telling me now all of a sudden escrow wants the paperwork. And I was wondering, why didn't they want the paperwork before? They trusted the listing agent to tell how much they were getting, but now they want to see the contract. So that's the way it is. I mean, it's up to escrow. How much they trust you, I guess. I don't know. They have new guidelines or whatever that they need to do this, but I always thought it was funny in the old days that they didn't need any paperwork. But I guess you would always complain if you didn't get, you knew what you were supposed to get paid, and if you didn't get that, you'd raise a big, holler about, wait a second, the MLS said you owed me this. What do you mean I'm only getting that? So, but now there's no MLS that anyone can look at. It's all the paperwork. I don't blame escrow for wanting to see it. If I were escrow, I'd ask for the listing contract and the buyer broker contract. Why not? The mic is coming.
My experience is that escrow is always asked for verification. There's always a commission instruction.
Right, but did they used to ask to see the listing contract? Yeah, of course you have to sign something. But they were trusting you to sign, but they were still trusting what you said. Right? Right. I know what you're saying, but they never used to ask to see the fundamental document. If everybody's honest, there's no need, of course. If everyone's going to sign the commission disbursement instruction. By the way, here's another question. Do you as the buyer's, remember in the old days when you were the buyer's agent, right? And the MLS offered you 2.5. You were always thinking, is listing agent getting 2.5 or are they getting 3.5? You always wanted to know what the listing commission was, right? Because you somehow felt that you were entitled to half. You were never entitled to half. It was never any of your business how much the listing agent was getting paid. But that's still true now. I mean, as a buyer's agent now, you're not entitled to know what the listing agent is getting paid. And you know what? The listing agent's not entitled to know how much you're getting paid. Yeah, of course, you're probably asking their client for a credit, but that's not necessarily the full amount that you're getting. And you cannot demand to see, as the listing agent, how much the buyer's agent actually got paid. Just like you've never been entitled as the buyer's agent to demand to see, I want to know exactly how much the listing agent is getting paid. So nothing has changed in that respect.
Hi, Gov, do you think procuring costs has gone away with the BRBC? If you're the listing agent,
Yeah.
you show the property to a prospective buyer.
Right.
They're reluctant to sign a contract. 2 days later, you get an offer from
Yeah.
another agent that never even showed the property.
Right.
Yeah.
You're right. Procuring costs is basically gone. Because in the good old days, the standard issue would be, I'll use your example. Listing agent, you showed the buyer the property, but they'd rather write it up with their brother-in-law, right? So, or two different buyer's agents not even related to the listing agent. Agent number one shows the buyer the property, agent number two writes it up. So the question is, which one of those should get paid? The one who showed it or the one who wrote it? It was never a clear question, so typically those two agents would go to arbitration at the Board of Realtors, and it would be the responsibility of the hearing panel of 3 realtors to decide who was the true procuring cause. It doesn't matter anymore. You know who determines who you get paid? The contract. So in your scenario, if the listing agent showed this buyer the property, but this buyer wouldn't sign a buyer-broker contract with that agent, they write up with someone else, that's who gets paid. On the other hand, what'll sometimes happen is buyer signs 2 buyer-broker contracts, which they're allowed to do if they're non-exclusive. But then they have broker A, broker B. Their broker A agent shows them the property. Their broker B agent writes it up. Who gets paid? Both. Those agents don't have a dispute anymore. They both have a dispute with the buyer, who was naive enough to sign 2 contracts. Now you can sign 2 contracts, but you have to read them, because the buyer-broker contract says you earn a commission by showing or by writing. So yeah, you can theoretically have 2 non-exclusive buyer's agents, but those agents need to tell the buyer, you can have another agent, but if I show you something, you got to use me to write it up, because if you use someone else, you're going to owe me a full commission and them too also a full commission. So people don't necessarily understand this. But to answer your question, procuring costs is basically gone. ADR, like NAR lawsuit, you said. I don't even keep track anymore. There's constant lawsuits about all this stuff. They take years sometimes. I think there are other lawsuits, not challenging the fundamental thing that I've been talking about, but there's still issues out there, yeah. If you really need details, call me and I can figure it out for you.
Gov, just to wrap this up.
Yeah.
Back to the bonus test case, if it is compensation or not. We are now seeing offered in the MLS bonuses to buyer's agents. Is that a violation?
So I assume this bonus is being offered by the seller, not the listing agent, right? So you should go away from listing agents providing anything. The question is, can sellers do this? I think it's a bad practice. I'll tell you why. Logically, it doesn't make sense. I mean, why would a seller offer incentive to the buyer's agent? Because that's trying to induce the buyer's agent to steer the buyer to properties not based on what's best for the buyer, but what's best for the agent. That was the whole thing behind these things, that shouldn't be the case. If you want to get activity on your listing, give incentives to the buyer. Reduce the stupid price.
Right.
You know what I mean? Don't give an incentive to their agent to bring you the property, because what are you trying to say? You're trying to say to the agent, convince your buyer to buy this house rather than this other house, not because it's best for them, but because it's best for me. Which is why if you look at it that way, that was the problem with the old system, is because listing agents were trying to incentivize the wrong person. We better offer buyer's agents more money so we can get some activity on your listing. Well, in other words, that's not the way to incentivize someone. You should incentivize the buyer, not their agent. So if you look at it that way, I don't think and I think those are going to be the next lawsuits. So that's a steering issue. This is what we're all trying to avoid this, which is why the good thing is the buyer is determining their compensation. So I wouldn't do that. Yeah.
So actually back to that, because that's really interesting, because I was reading the RLA yesterday, because just periodically with all the updates. There is a line there, and I want to make sure I'm understanding it correctly. It only gives sellers the option to advertise concessions, period, not specific concessions. So is that permissible? That can't be permissible.
That's probably not even submissible under the, but the question is, they can't offer concessions. Is advertising the same as offering?
Right, but not being specific.
But I'm saying don't do it anyway.
Yeah.
Yeah.
And then my other question is, I'm starting to get a lot of new construction buyers, which a lot of us are. How is new construction getting away with continuously all of them advertising what commission they're offering, what incentives they're offering? How are they getting away with all this?
Because they're not, I mean, it's really considered like referral fees, really, because they're just, and isn't it typical that a buyer's agent, you don't really help the buyer, you just bring them to the builder and go away, right? That's what they want you to do, go away. So, yeah, I mean, that's perfectly okay. It's perfectly okay for a seller.
Even if their verbiage is, because some will
Yeah.
say referral, you walk away from your
Right,
client, you take
right.
it over, and some will say, no, you're still their agent, it's a commission they're offering.
Yeah. No one has questioned that. Okay. Yeah, so the builder thing is considered okay. By the way, to tell you the truth, if you just show up, I hate to bring this up because now you're going to all take this and go running with it, but but this is gray. I think it's not 100% is. If a builder is saying, just show up, register the person, and go away, and you're not even showing them the model, that's a pure referral fee, and maybe none of this covers that at all. And there's no, and that might not even. One of you needs to make that argument, go to court, and say what the judge says. Your argument would be, yeah, my buyer only agreed to pay me 3. Yeah, the builder offered 4. But that's not really covered by the settlement because that is a pure referral fee because I didn't do anything for I didn't even show the buyer. I was not involved because none of this covers referral fees, right? I mean, forget builders. Agent sends you a referral. And you pay them for that. That's not covered by the settlement. You can do whatever you want. A pure referral is not a commission. It's not covered by anything I've been talking about. So can builders get around, can you get around this whole limitation by, it's a pure referral. You tell me if I'm wrong, typically when you bring a buyer to a builder, don't you show them the model?
Yes, and they want you there.
Yeah. Then that's not a pure referral. It's not a pure referral. Yeah, so it really is. So in other words, it's just like any other seller paying. But no one is challenged. I know what you're saying. Well, are builders getting in trouble then by trying to incentivize? But don't they offer it to everybody though? Yeah, I mean, so I'm not really worried about that one at all. Yeah.
Gov, the builders are getting away with this because they are incentivizing, they offer all these bonuses you get by selling their properties, but it's only conditioned upon them using their lender. So it's coming out of the lender as opposed to the builder.
Yeah, you're right. I'm not worried about the builder situation, but I am worried about the argument that the amount in your buyer-broker contract better be as high as what the builder's paying. Because then I think you have a problem if you get paid more. Maybe not, but we're pretty sure on that one. Yeah.
Okay, so this has happened to me several times, and I want to just read this text message that I got, and this is like the 3rd time I've gotten this. Hello, I'm requesting a showing for your listing in Bakersfield. I need to confirm 2 things, that the seller is offering 3% to the buyer's agent so I can even show.
Yeah.
So I haven't been spicy enough to report anyone these specific days, but this is about the 3rd time that it's happened.
Yeah, I mean, if I were the seller, so if you would say that to me, if I was your seller and someone asked me for that, I would say I'm not going to commit to anything. Why would I? My response as a seller would always be, you write a good offer, I'll pay you whatever you want. If it's not a good offer, I won't even accept it. So I'm not going to commit to pay. That's just like they wouldn't ask you to have your seller commit in writing that they'll pay X amount towards repairs before you even write the offer. Or you wouldn't ask them to commit to pay title, escrow, and NHD fees. So they're just sort of, and we see this all the time. They're just not getting the whole, can I say that's per se illegal to do that? Arguably, but I can't say that's illegal. I'm just saying it doesn't make sense. Yeah, don't even respond is the best response because, if you want to respond privately, say, shouldn't you be showing your buyer all the houses that are in their interest to see? And isn't your buyer agreeing to pay you? Oh yeah, but my buyer's not going to pay me. Okay, well, ask for a credit. I mean, you don't have to have this conversation, but the logical response is every seller in the world who's rational will pay the buyer's agent's compensation if it makes sense, if they're getting what they want. So, yeah, I mean, at the beginning, that was every time. And that's, in other states, that's very common. It's not as common, but it still happens. It just doesn't, from everything I've just said the last half hour, you get why I would say that's just not a good practice. I can't say it's illegal.
Those kinds of requests are coming out of LA.
Yeah. They're not necessarily local agents, yeah. And you can come back and say, well, keep your lazy butt back in LA and don't come up here, you know? I mean, whatever, you know. Go ahead.
Hi, Gov. The Assembly Bill 2992.
I don't keep track of numbers. Tell me what it says.
Okay, sorry. Okay, so this says that on January 1st, under this law, California passed this law, and it says that on here that the members of the or use of MLS before or by time of making an offer. So basically, it's a, oh my God, I think I lost so basically saying that you could sign a BRBC prior to or by the time you make an offer.
Right.
That's what this is what.
Right. That's
right.
what's going to
So-
change by this regulation that's coming out. Remember I said today, it's absolutely true, today, California law on non-residential prop doesn't require you to have a buyer-broker contract in place just to show. The regulation that's coming in a month or two is going to say, no, you need it to show.
Okay.
So what you're quoting is now that I realize what you're quoting, that's the existing law that was passed January 1st.
First, yes.
And you're right. Under California law, you can show without a contract. But the settlement, which applies to residential property, supersedes that with respect to residential property. And very soon, the regulation is going to make all types of property sort of the same. So what you just said is true for now.
Okay.
Yeah. Now I remember the number. Yeah. Yes, sir.
I don't know who's in charge of the forms.
Not me. Yeah. Right. Yeah.
But I just recently wrote up a purchase contract, and in the commission put 2.25%. It only allows 3 spaces. So there's not the 4th space, so I'd ask for 225% commission. Told the agent, just so you know, I'm expecting it.
Good comment there, yes. Just a good idea. No extra space, okay.
Only 3 spaces.
There you go. Good to know.
That's what I said. That's what my wife said.
Asked for more. Wouldn't give it. Oh, well. Any more good questions like that? So read the email you get in 4 days. If you don't get the email, that means C.A.R. doesn't have your good email address. What do you do when you think there are C.A.R. emails? Some of you are saying, I get too many C.A.R. emails, I don't want them anyway. But I think you all would like to see, hopefully, the one that's going to come out Monday summarizing all the new laws. If you don't get it, don't call C.A.R. You have to work with the great staff you have here and tell your great staff here, could you please make sure C.A.R. has and tell them the email you want so you get our stuff. Some of you, I know, a lot of you say, we get too many emails from C.A.R., I don't read them. That's fine. I'm just recommending this particular one. Read it, because those things that I mentioned today that might happen, we'll know for sure if they did happen. Mainly the Zone 0 thing, that was a big one, and the wood balcony thing. So, and there may be a couple laws I'm not even aware of that may affect you. I don't think so. I think I know pretty much all the laws that have either been signed or that are relevant to you that may sign. If you really think about it, that was good news, right? Because the legislature sent about 1,000 laws to the governor this year. And the ones relevant to you, even if he signed them all, it was less than 10. That's not bad. It's not a bad year for new stuff. Last year was a bad year, buyer broker. Who knows what next year we'll see? You know what we're going to see next, of course? AI stuff. You know what else we're going to see? TC stuff. Some people say TCs have too much power. Well, then don't give them so much power. You know, whatever. You know. And the other one, the other theme I hear every day is we hate HOAs. We need to regulate HOAs. We'll see what happens. Okay, see you next year. Bye, everybody.